Hello, everyone. My name is Greg Sofer, and I'm a partner here at Husch Blackwell's White Collar Internal Investigations and Compliance team. Before we begin today's webinar, I want to cover just a few housekeeping matters. At the bottom of your audience console, there are multiple application icons for your use during the program. If you have any questions during the webcast, please submit them via the question box. We'll try to answer all the questions during the webcast today, but if a fuller answer is required or we run out of time, we'll try to answer your questions via email later. A PDF of this presentation will also be available in the program materials folder on your screen. This program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We'll use your feedback to plan future programs that are applicable to your business needs. That's all for the housekeeping items. Let's get started with our program. I'm going to do short introductions of our speakers because we have a lot of material to cover and not a long time to recover it. So joining me today are Jeff Jensen. Jeff is a partner in Husch Blackwell's St. Louis office. Jeff was an FBI agent for 10 years before he became a federal prosecutor at DOJ, where he eventually served as the United States Attorney for the Eastern District of Missouri. Jeff has also spent the better part of a decade in private practice, where he has successfully led complex, high-impact internal investigations and litigation for clients ranging from Fortune 50 companies to small companies. Rebecca Furtick has joined us. She's an associate in Husch Blackwell's Milwaukee office, where she conducts internal investigations using her experience inside and outside the government. Rebecca served as counselor to the solicitor at the Department of Labor before joining our firm. She's well-versed in the complexities associated with conducting high-stakes, challenging investigations for both corporate and individual clients. Chris Budke's joined us as well. He served for more than 30 years as an FBI special agent and supervisor. Chris participated in more than 50 significant and complex investigations while at the FBI. He now works closely with attorneys in our group, often utilizing his extensive experience in interviewing difficult witnesses under difficult circumstances. Sal Hernandez is a former senior executive with the FBI, having served as Deputy Assistant Director of the Criminal Investigative Division and the Assistant Director in charge of the FBI's Los Angeles Division, where he supervised more than 1,300 FBI employees. Sal also served as Vice President of Compliance and Ethics for Enterprise Holdings, Inc., the world's largest vehicle rental, leasing, and sales company. The combination of his government and private sector experience make him an invaluable source of information in the internal investigation space. And finally, me, Greg Sofer. I started in the Manhattan DA's office in the early 1990s. After 9/11, I left New York City to go to Washington, D.C. to do national security and counterterrorism work. In around 2007, I moved to Texas, where I started as an assistant U.S. attorney, eventually became chief of the criminal division, and eventually also appointed as the United States attorney, with a stint as counselor to the Attorney General Barr in the D.C. DOJ headquarters. That's a brief description of our backgrounds. If you want to see our full backgrounds, there's a link to our presenters' bios, and they can be found in your invitation to the webinar. So with that, let's get into the nuts and bolts of internal investigations. Before we start, I just want to say that this really is a nuts and bolts presentation. Any one of these slides actually could be the subject of an entire presentation. So we're trying to cover a lot of ground and just cover the basics. And I should also say that we really are focused on investigations where there could be government compliance issues and government enforcement issues that are looming. A lot of investigations are conducted. There is no government enforcement. There's really no concern. There are personnel matters. There are other internal issues. And there's never a report or even necessarily a concern about reporting it to the government. But given our background and our focus today, we're going to really try to focus on the nuts and bolts of internal investigations where government enforcement is looming. Here's sort of an overview of what we're going to cover. We're going to talk a little bit about preliminary considerations in an internal investigation, data retention, the plan, the internal investigation plan, the scope and the procedures that are used, data and document collection, interview preparation, interviewing itself, conducting an interview, and then ultimately creating a record, and ultimately creating an investigative report. And while we go through this, we'll also focus on issues that relate to privilege and also the interplay between compliance programs and internal investigations. With that, I'll turn it over to Jeff because Jeff, the world has changed a little lately, and DOJ, and not just DOJ, but a lot of the government agencies have made it clear that they're really ramping up corporate enforcement, haven't they?
They have. Thank you, Greg. Thanks for including me, and thank you, everybody, for being on. I think it really started in October when Deputy Attorney General Lisa Monaco gave a speech in Miami and talked about many things. The most important points were that for companies to get credit for cooperation in an investigation, they will have to give up information on all of the individuals involved in misconduct. They'll also consider any prior misconduct of a company. And she said that corporate monitors, DPAs, deferred prosecution agreements, non-prosecution agreements are no longer an exception, but will be more enforced. The Attorney General himself reinforced this in March of this year. And even since then, an Assistant Attorney General, Polite, came out with a statement that CCOs and CEOs are going to be required to certify the effectiveness of a compliance program at the end of a DPA or an NPA. So we are really in a new environment. So the question becomes, when do you conduct an internal investigation, and what are the common triggers when you know it's time? Some of them are obvious. You receive a subpoena, a complaint, a hotline tip, things that are potentially, as Greg said, potentially outwardly facing. It's not just an internal complaint, but it could put you in front of the government at some point. That's probably that you certainly know you need to conduct an investigation at that time. Whistleblowers, though they can be sometimes lack credibility, often lack credibility. They can get quite a bit of government attention for a while. And then there are certain industries that are focus of the government currently. What we've seen quite a bit of is healthcare investigations, environmental investigations that would normally be regulatory, civil, administrative matters are now being criminalized. And DOJ is coming in with criminal investigations. And in particular, DOJ, they're sending their AUSAs out from DC to the provinces to assist in those investigations. So it's getting aggressive. Another area of focus we've seen are SEC cases, parallel cases with DOJ. The triggers for those are typically harder to see. I've prosecuted many and defended many what I'll call quarter end cases or timing cases. Those are back. There are an infinite number of ways, excuse me, that companies can pull revenue forward or push expenses out or push expenses below EBITDA. Straddle transactions where one part of it happens before the quarter end and the other part happens after the quarter end, none of which are per se illegal, but if the purpose of those transactions is to artificially inflate results, the SEC is getting, again, aggressive on those cases as they once had been. So typically when you have one of those triggers, it's time to conduct an internal investigation as opposed to just responding to government inquiries. And the reason for that is because the ultimate question here for us for any of these cases is is it fight or flight? Do you want to cooperate with the government or do you want to contend their allegations? And if you do want to cooperate, when do you want to cooperate? Do you go in right away? Do you wait for a while? There are infinite number of considerations and implications. Obviously, sometimes reporting is mandatory. Sometimes it depends on the reasonableness of the particular enforcement person, AUSA, or whatever that you're dealing with. There can be publicity concerns. how will this impact any future employment actions now that this will become sort of part of the record? And then you can have transactions, for example, the sale of a company where the findings will be important. But ultimately, to make those decisions, you have to know the facts. You just have to know the facts, at least the ones that are available to you. Sometimes you don't have visibility into what the government knows. They're talking to whistleblowers. They can have wiretaps, even in white-collar crime type investigations. They do all kinds of media surveillance. And you won't know the whole picture, but you need to know what you can in order to make informed decisions.
So Sal, this is sort of started the conversation about why it is that an internal investigation might be important. There's other reasons for that as well, aren't there?
Absolutely, Greg, and thank you to the audience members for joining us today. We appreciate your attention. I'm going to cover just a couple of things here, and then I'll get back to it toward the end with respect to the value of compliance programs in corporate America. Before I talk specifically about cooperation, I'll just mention the first bullet point references the U.S. sentencing guidelines, which were promulgated in 1991. And for anybody in the audience that's worked in or around compliance, you're familiar with Section 8, which is the set of organizational guidelines. And those, as well as the rest of the guidelines, were established to really meet two key purposes of sentencing: just punishment and the creating of incentives to deter criminal activity. And this section of the sentencing guidelines, Section 8, has really become the source document for all compliance programs. And one of the key elements there for purposes of our presentation today is that in sentencing, judges will take into consideration the level of maturity of a compliance program. And they do a really nice job in the guidelines of telling you what the 7 key elements should look like to call, or to be able to call your compliance program effective. But for the purposes of this slide, I just want to make sure that everyone understands that when it comes to cooperation, this is pretty well established, that if a company does cooperate, it will be given credit. And to the extent that they cooperate more fully, perhaps more credit. If they volunteer information more readily, perhaps more credit. And as Jeff mentioned ago, that's a really key consideration, not one to be taken lightly. Sometimes it's appropriate when a regulation requires to disclose right away to the government. Sometimes it's not appropriate. And it's one of those things that I think requires a lot of thought before the decision is made. But to make no mistake, credit is given to those companies that cooperate and cooperate more fully. And then this is just a follow-on to that. The two key documents that anyone working in compliance relies on when trying to consider what a prosecutor might do in making a charging decision are first the evaluation of corporate compliance programs, and I'll refer to that again later as the ECCP, and the Department of Justice's Justice Manual. And as I said a minute ago, those things, both of those documents talk about the willingness of companies to move forward voluntarily in a timely way to provide information regarding whatever the wrongdoing might be.
So, I mean, you can see here that we're in the section of the presentation that talks about why, and obviously a big why you would conduct an internal investigation has to do with potentially cooperating or disclosing. A very, very difficult choice, as Jeff points out, very complicated and potentially fraught with danger. So not understanding the situation, not knowing the facts, not knowing everything that you can possibly know before making that decision is a very dangerous place to be. And again, you can see that this is a major motivation both to conduct an investigation, but also conduct one in a timely fashion and in an efficient way. But it may very well be that, in fact, you don't want to disclose everything, and you don't know necessarily at the beginning whether you're going to want to disclose. So the question of privilege and disclosure is huge. And Jeff, if you wouldn't mind talking a little bit about that.
Sure, and just backing up to one point, if you are cooperating or disclosing to the government, not necessarily cooperating, presenting to them, credibility is everything. I mean, it's absolutely everything. If you lose credibility in a case, then you're done for that case and maybe future cases. So not understanding the facts well and going in and risking presenting the wrong facts can be really detrimental. But you're right, it gets tricky around privilege and work product doctrine issues, because you don't know up front whether or not you're going to want to waive. You don't know all the facts yet. You don't know all of those factors that I talked about earlier. You essentially have 2 or 3 protections. You have the attorney-client privilege, obviously for communications to obtain legal advice, and then you have the work product doctrine, which breaks out into opinion work product and ordinary work product. Opinion work product is more protected. They're often moving parts. If you're using agents like we do for interviews and parts of the investigation, is that covered? The answer is yes, so long as they're acting at the direction of counsel. If you make presentations to the government, you're always risking waiving the privilege, especially if you include in opinions as opposed to just the raw facts. And so that the ultimate problem is you don't know up front whether you're going to waive or not. So you want to stay flexible in your investigation. And the best way to do that is to mark documents appropriately. Don't over mark documents as privileged. Don't underdo it. Either way, it can cause problems. I like to have people include in their interview reports opinions, because that opinion work product has a higher protection than if you choose to turn over the document in its entirety. You'll be waiving the privilege, but you can redact it those portions of it later and turn over just the factual portions and avoid waiving the privilege. And then when you do, again, report a final report or final presentation to the government, make sure it's purely factual and not laced with opinions, because that's where you get in trouble, at risk of waiving work product or the privilege.
And there's been a lot of litigation about this of late, and the law seems to be moving and expanding in different directions. There was recently a case in New Jersey, which I think frightened a lot of people, about accidental waiver of privilege. So it is definitely something that people have to be very sensitive to. And we'll cover some more of this issue in detail as we move on. So we sort of talked about why you might start a internal investigation, and let's assume you're going to get started. Well, the first question logically may be, who is going to actually conduct the investigation? And that's a difficult question. It can be a lot of companies, for instance, have an internal investigative capacity. They conduct investigations all the time. You can also engage outside counsel, or there can be a combination of those things. And some of the things to think about when deciding whether or not to, for instance, bring in an outside counsel, such as our law firm, it has to do with some of the knowledge issues of the company. That is, you don't want people conducting an investigation and know nothing about the business. If there are particular complexities of the business, those folks who do the investigation have got to be up to speed on that, or a competent investigation may not take place. Some of the conflict and privilege issues that Jeff touched on and that we'll get into later are important here. There's a school of thought, at least, that says that an outside law firm is going to be able to protect the privilege more securely than an internal investigation conducted from inside the company, because one of the ways the privilege is busted or broken is if there's an argument that the internal investigation was conducted for a business interest and not for providing legal advice. And sometimes that's more easily done if there's an outside law firm brought in. Everyone has to be comfortable, the officers, employees at the interviews. Again, as Jeff points out, we use federal agents or former federal agents who are well-versed in this. Sometimes, though, people will be more comfortable talking to someone inside the company. Those considerations have to be taken into account as well. Then there's just the optics. When the Department of Justice, for instance, is looming in the background, to do something inside, particularly if you have a serious case and it involves insiders in the company, sometimes the optics are just simply better to bring in a third party. And then particular legal or other expertise is often something that you're looking for, depending on the nature of the investigation. So when you start...
Greg, let me interrupt you there. There's a question from Rodolfo Rivera about how these corporate, essentially, prosecutions differ from the regular situation where people come in and get immunity, or probably more often get 5Ks, which is a downward departure motion based on cooperation. I think it's the same legally. But conceptually, right now, with the Department of Justice, they are going after hard, the corporations and those high-level individuals. So it does give you a terrible choice. Sometimes the best way to protect the corporation is to throw individuals under the bus, depending on the facts of the case. But they are putting people in that very difficult choice.
And that goes back also to the conflicts issue we've discussed, which again, we'll get into in a little more detail in a little bit. So what are the big sort of goals when you're going to conduct an internal investigation? Again, these are broad strokes and don't necessarily apply exactly to every single situation, but generally, this is what you're looking at. You want to understand the nature and extent of wrongdoing and the potential liability for the company, for potentially its employees, its business model. As Jeff pointed out, there are publicity or public relations issues. There's potential of lawsuits, and all of that, you have to understand the potential liabilities. You have to identify responsible parties, potentially impose some sort of discipline, and take necessary corrective action. One of the things that's really difficult is if there's any kind of ongoing harm taking place, that action has to be stopped as quickly as possible, and sometimes that makes the investigation even more difficult. You need to gain control in preparation for possible civil or criminal action. That's similar to what I've just described. You want to reduce exposure via disclosure of wrongdoing. Again, this is an incredibly difficult decision that has to be made. Sometimes it has to be made very quickly. As Jeff points out, sometimes there are mandatory disclosure requirements. And so that's something that has to be considered along the way. And you want to avoid investigation and enforcement action by authorities. If the investigation is started early enough, if one of the triggers is not somebody showing up with a subpoena or a search warrant, instead it's something that your compliance program has found early, sometimes the investigation can actually preclude and cut off at the pass any kind of enforcement action. Of course, that's the best case scenario. And then here are just some other considerations. Again, you got to be extraordinary. These are sort of mines in the minefield. You got to be careful about this conflict of interest question. You have to understand what your review capability is. Sometimes the investigation is so broad and deep that it's hard to actually get at everything. And you really have to have a plan to try so you understand the universe of what you have to look at, and you have to identify how you're going to attack it. And there needs to be a protocol or a plan. We talked about privileges. We're going to talk more about preserving documents in a few minutes here as well. You need to start thinking about how you're going to document this, and that's extremely important. That needs to be done in advance, not on the fly. You don't want to be building this airplane in flight. You need to be giving those issues a thought along with waiver. The DOJ's guidance on best practices, if in fact DOJ is looming out there in some form or another, you want to take a look at that. That may color the way that you move forward. You have to do this terrible assessment of timely self-disclosure. Again, sometimes it's easy, but sometimes it's just an agonizing decision about what has to be disclosed and when and to whom. And then you got to start thinking about when you go out there and start interviewing your employees, what are you going to tell them? How are you going to tell them? Who are you going to tell what about all of this so that you can control the flow of information and who knows what? So those are the big strokes in terms of what you have to think about. Rebecca, you've done a lot of these investigations. Can you take us through sort of the first steps that you and investigators actually take when you commence an internal investigation?
Absolutely. Thank you, Greg. And thanks to all of you for joining us today and the opportunity to speak to you. As these prior slides suggest, there are a number of considerations obviously at play early on in an investigation, and therefore it's tempting to get a little lost in those or some of the more interesting factual details early on. However, it's very important to just step back and make a few key decisions early on. First, get a sense of what the investigation is going to involve. If there's a subpoena, is it broad, vague, and probably unhelpful? Or other times, the subpoena may have very clear, specific requests, and it's easy to get a sense of what they're really looking for. Second, while this, of course, won't be your final determination, it is very helpful to make an initial determination of whether there is a credible indication of a violation, either of law or of company policy. Again, this may change over time, but it's good to get that initial sense because it will really help steer how you structure the investigation. Third, to the extent that your initial determination finds a credible indication, it's important to just cut off, to terminate any unlawful or wrongful conduct you're aware of. In other words, don't wait until the end if you see something now. Fourth, preserve relevant records. Again, what is considered relevant may change in the course of your investigation, but by making some initial assessment early on, you can certainly get that process rolling. And then finally, and we'll discuss this a little bit more in depth, confirm and structure your formal plan of investigation. So in terms of scoping what your investigation is going to look like, there's a balancing act to be struck between having a focused, targeted investigation with a sufficiently deep enough review. Because on the one hand, you don't want to over-collect documents and be stuck with a extremely high volume of documents that are irrelevant and will just slow you down from making those important decision points. However, on the other hand, you don't want to scope your investigation so narrowly that there's no practical ability to get a full sense of the issue. Keep in mind that you can always expand the investigation based on your initial findings. It's really not uncommon in the course of internal investigations to learn new things and to take some new directions that you didn't anticipate early on. And finally, just keep in mind a very key goal. Your goal is to allow prompt corrective or remedial action in the event that there is any potential wrongdoing uncovered. And then there are just a few challenges to keep in mind. These may vary from investigation to investigation, but these are some common ones. First, you may confront a temptation to delay investigations of reported or potential wrongdoing. And as Jeff alluded to earlier, there are many considerations at play about reporting and the timing of that. Another challenge can be the ability to conduct timely investigations and limitations on access to documents and witnesses. Sometimes it's just a scheduling issue and to hear back from people. Sometimes it's just difficult to collect the documents you need, which again, that's one of those goals you should set early on in a consideration of just starting early to get those documents. And then there's various factors just relating to the timing. And I believe both Greg and Jeff touched on some of these. There's reputational risk as well as obviously legal and financial, whether your investigation will intersect with a government investigation, the ongoing nature, if applicable, of any potential wrongdoing, as well as loss of access as a practical matter to both your key witnesses and documents. And finally, we will touch on this later on, but one challenge can be the way you document the basis for your decisions in the investigation. And then finally, so one issue we've touched on a couple of times now is the importance of document preservation to get that hold notice out quickly, to begin collecting the relevant documents. So issue that hold notice and direction on document handling and preservation. Sometimes so much is going on early on, but it's very, very crucial to do this right away. And in the course of your investigation, to the extent that the scope varies, you may need to update that preservation notice. And these next three, COVID really spurred this along, but more and more people don't just leave work at the workplace. They have work email on their phone, they're often their personal device. You may have to deal with preserving custodian work-related emails on personal devices. It's important to issue instructions to that effect, as well as communicate. You may not be surprised that sometimes employees are confused about that, the nature of how the collection works, what is actually collected, what is not. So it's important to just disseminate clear guidance to that effect.
So you've started your investigation, you've considered many of the things we've talked about. You're now going to be collecting the evidence. We talked already a little bit about data retention. I think most people know what a litigation hold is. even this can be extremely complicated. After the litigation hold is issued and you scope it according to some of the factors that Rebecca just talked about, and understanding that that may be a dynamic decision as well. The next question is, who's actually going to collect this stuff? And, you know, I have regularly already run into plenty of places where understanding the IT systems is critically important. Some companies have very up-to-date, concise, interesting IT systems. Other companies are not as advanced, and it can be a real IT challenge. So understanding the IT issues is an important concept at the beginning. You have to understand those operating systems. You also have to understand all the sources of data. And Rebecca touched on this. I think it's changed over time, especially as law firms and companies and everybody has really moved towards more remote work. But obviously the company may have its own proprietary servers. It may store things on a cloud. There are shared drives, sometimes in numerous places. Your just regular standard business documents sometimes get lost as to where they are and where they might be. You have to try to have an understanding, again, of the company and where it puts the sources of its information. Obviously, emails, text messages, chats, all of the encrypted messaging services that people use. They may be using them on their work phone. There are issues related to that as well. And then obviously phone records, voicemails, the more traditional way of storing communications. So assuming that there's a way of centrally doing this inside the company, that's one thing. But again, as Rebecca points out, these days, these devices are moving all over the place. They may be moving all over the world. And so it's pretty easy to get the ones that the company can see and can pull centrally, but it's much more challenging when these devices are running around the world. And you have to think about that. The custodians might want to back up their devices. There could be issues about surrendering devices. A tech visit sometimes has to be scheduled just to get things off of a device. I generally counsel people that we don't want people, particularly if they could be targets of the investigation, collecting their own information, because the government may look very skeptically as to whether that search was done in a proper way, especially if they were concerned about their own rear ends. Hard copy documents still exist. Believe it or not, we get boxes and boxes of documents still on occasion. And so to get them scanned, to get them searchable is something. And Rebecca pointed this out, you know, there's really a true danger these days of over collection. You could actually get so much stuff that your investigation will grind to a halt, but casting the net out widely and then trying to prioritize what exactly we want to look at is critically important. So again, that's the stuff, the documents, the communications, maybe the business records, but the critical piece in many investigations is actually interviewing witnesses. And I think that from what I have seen, that, you know, this gets in a lot of presentations and a lot of materials that are available, this gets pushed off to the side a little bit. And really, unless you're good at understanding what the issues are with respect to interviewing witnesses, and unless you have people who are really talented at interviewing witnesses who are coming into this investigation in various different ways, they could have reasons not to tell the truth. They could have reasons to say something bad about somebody else. To understand all of those perspectives and the way that people act under these circumstances, it's very helpful to have somebody who's really well-versed in this. And that's one of the things we're going to talk about. But again, you can't start this without at least thinking about potential conflicts. And Jeff, if you could walk us through a little of that, that'd be great.
So again, the witness interviews are key. They can make an investigation so much more efficient, save you all kinds of time, and get to the point much more quickly. In order to keep them privileged, however, you need to give Upjohn warnings. So all witness interviews should start with Upjohn warnings if you intend for the investigation to be privileged, and probably you don't know at that point, so it's safer to give them. The typical problem with Upjohn warnings is that it can kind of scare people off, frankly. So if you start out by saying, we represent the company, We don't represent you personally. Everything we're going to talk about is privilege. However, it's not your privilege, it's the company's privilege. If you choose to disclose information, you could waive the company's privilege. Well, at some point it starts to sound like a Miranda warning, and people sort of shut down. So that's one major problem. The way I typically handle that, I think the best way to handle that is with the truth. I start out with telling people, you know what, I'm about to give you some warnings, and it's not unique to you. It's not something that we do only for you. We're giving the same warning to everybody we talk to. So does every other law firm who conducts internal investigations, because the Supreme Court says we need to in order to maintain privilege. And then people sort of get it at that point, then go through the warnings, much more likely to talk to you at that point. The common problems are people that just refuse. They just don't want to talk. And that usually gets down to an issue of company policy and procedure, whether or not they're required to. Another problem is sometimes people will hear it and say, well, do I need my own lawyer? And the answer to that is you can't take a position on that, as when you're conducting an investigation. Advising them as to whether or not they need a lawyer is in and of itself legal advice. So you need to not answer that question and say it's really up to you. The company policy says this, or the company policy doesn't say that. But again, I think the way to get through 99% of the problems is to give a little preamble, a little explanation of the point of Upjohn, and then people almost always are willing to talk to you.
So we'll turn it over now to our former federal agents, and interviewing people, assuming you can get through the issues that Jeff just described and there's no legal impediments to moving forward, again, is something that people spend, in many cases, an entire career working on the best way to do this. So Chris and Sal, why don't you try to take us through sort of the nuts and bolts of actually conducting the interviews?
Thank you, Greg. It should not be surprising to anyone that the success of an interview largely is based on the amount of preparation that went into that interview. So I want to focus a little bit about some common steps you might take while preparing for interviews. And I'll start with the review of the client company's personnel policies. You want to pay attention to employee conduct expectations, requirements for employees to cooperate during investigations, or expectations of truthfulness during investigations. And it may also be appropriate to examine key witnesses or subjects' personnel records in order to learn as much as possible about their past performance issues or misconduct. I cannot overstate the value of reviewing compiled documents and files for the purpose of informing interview decisions and strategies. Document reviews often add clarity to the alleged misconduct. They help with the identification of interviewees. They help identify critical interview exhibits. And so before beginning interviews and after the document reviews, you should compile a list of all potential interviewees, including internal and external, and assess their availability. And from that list, you can develop the order of the interviews. Typically, it's best, the best results are obtained by interviewing in this order. Start with the victim or the complainant. That way you can obtain as complete picture as possible of the issues at hand. And it also assures the victim or complainant that the matter is being taken seriously. Next, move to non-material witnesses. Those are witnesses that can provide the necessary background on policies and procedures and confirm data retention efforts. And then next, move to the material fact witnesses, individuals who have information directly related to the claim. or the allegation of misconduct. Next and last, you will interview the subject of the interview. That interview should be done last, because that is when you have gotten the full, complete picture of the allegations and the facts behind them. Staffing of the interview, we recommend that you have two interviewers with the interviewee. In case the interviewee alleges some different statement later on when the interview's been recorded. Lastly, we would say don't have more than two interviewees. When you have more than two interviewers, the interviewee can feel as if they're being ganged up upon. So it's rarely a good step to have more than two interviewers. The location of the interview should be a neutral location. You should avoid conducting interviews in areas where there's common business activities going on. Pick a location that's neutral to the employee, such as an unused office or a rarely used conference room. If the investigation, there's a need to maintain confidentiality with the interview or with the investigation, you should consider an off-site location, a neutral off-site location. This could be a hotel conference room or somewhere in which the interviewee does not feel intimidated by the surroundings around them. The interview room setup, ideally, especially when you're interviewing subjects or key witnesses, is to place the primary interviewer between the person being interviewed and the exit door. This gives a sort of a psychological advantage to the interviewer. But what you want to avoid is giving the appearance that the interviewee cannot leave on their own or is somehow forced to give a statement. But just placing yourself between the interviewee and the door does give you a little bit of an advantage, psychological advantage over the interviewee.
We got a couple questions, Chris. I'm sorry to interrupt. We got a couple questions about recording interviews. How do you record the interviews? And I assume that means, do you want to audio record them, or are they all written notes? And feel free for anyone of the presenters to jump in about your thoughts as well.
It's a great question, and it comes up in court all the time. As for example, the FBI or most federal agencies don't record interviews, and that's always the question: why didn't you record it? And I think that the truthful answer is that people are less likely to disclose information if they know they're being recorded. They just once that recorder goes on, people get very cautious with their answers, and you're less able to gather information that you need. That's my opinion, but I'm sure others might have other opinions.
I think Jeff, I think you're dead on right. There are instances, though, when actually having an audio recording does help. And a lot of times it's when you're past that issue. So maybe it's the second interview and you just want to make sure you get the details down in a way that come from the sound of the voice of the person who's actually making the statement. So I generally agree that having a recording device present is going to deter a lot of people from talking. You're going to have trouble developing rapport, which is on the next slide here, potentially, when you stick a recording device in their face. And covertly recording audio or video recording interviews has potential legal ramifications also. You have to be very careful about that as well. But there are instances when those things can be very helpful, and it's something that has to really be thought out. Let's go on to this slide for Chris and Sal.
Yeah, so Yeah, so when making your introduction to the individual you're being interviewing, I think it's most appropriate to be very upfront with the interviewee. Identify yourself, identify the firm you're with, explain who you represent. Those are all part of the Upjohn warnings. It's appropriate to advise the interviewee that you were retained to conduct the review or the investigation, and for the purpose of providing legal advice. That is part of the Upjohn warning that helps preserve the attorney-client privilege of the interview. It can be appropriate to provide interviewees with a general description of the nature of the investigation, but it's not necessary and oftentimes not advisable to provide specific details of the complaint or the identifications of other people being interviewed, or even the results of the investigation to date. You'll want to focus in the early part of the investigation on developing rapport, and you do that by essentially building trust with the individual that you are conducting the interview with. It's one of the most important skills as an investigator can develop, is to make sure that not only at the beginning of the interview to develop rapport, but to use techniques and methods to keep that rapport, keep building on that rapport throughout the investigation. You can establish rapport and build trust by using a warm voice and a calm demeanor. Use nonverbal actions such as a handshake or an appropriate physical contact with the interviewee at the beginning of the introduction. Maintain good eye contact with the individual. Lean forward as you are listening to answers. You build rapport by showing interest in the individual being interviewed. Ask them about their educational background or their work history, their personal interests. Use active listening skills throughout the interview to demonstrate that you hear what the interviewee is saying, and to demonstrate empathy and understanding with the interviewee's responses. You might take a different approach while interviewing subjects. Depending on the scope of the available evidence supporting the claim or misconduct, it may be appropriate to sort of suspend the niceties in the efforts to build rapport and rather than speak very directly. This should not be a hostile confrontational, but it should be just a very direct discussion. Sal, why don't you address some of the admonitions and warnings?
Sure, thanks, Chris. Hey, Greg, could you take us back just one slide for a moment? Thank you. We've talked a bit about Upjohn already. There are a couple other things that I'm going to mention. Most of these come from Supreme Court decisions that are based on NLRB actions, but I think they're important to consider as you're conducting interviews. In connection with Upjohn, there are certain assurances you can give to an interviewee around confidentiality. Obviously, you can't tell them that in every instance confidentiality will be respected, but you can say in most instances it can be, unless some sort of remedial action has to be taken. So sometimes that's a way of making a person a little more comfortable after they've heard Upjohn and they're a little concerned that anything they say is going to be revealed outside of the context of the interview room. In terms of requesting confidentiality, most companies' personnel policies, summaries, or handbooks require that employees cooperate and participate in internal investigations. And there are recent NLRB decisions from, I think, 2019 that say that while prior to 2019, it was very challenging because of concern over terms and conditions of employment under the NLRA to be able to ask an interviewee to keep the substance of an interview to him or herself. Post 2019, essentially, you can do that. You can say as a condition of your employment, you, during the course of this investigation, at least up until the termination of the investigation, are required as this condition of employment to keep the elements of this investigation to yourself. There are certain caveats, but it's much more wide open, and I think it favors the company internal investigator. A couple of other cases that I like to mention. These aren't all warnings, but I think they're worth noting as you conduct investigations, because frankly, I've seen these missed. And as important as giving these warnings and knowing of the existence of some of these considerations is documenting it in your interview report. So you want to make sure that you've told the employee, because every company has one, that the non-retaliation policy of the company will be observed. A ZAR is a reference to a case which essentially tells you as an investigator, interviewer, that if the investigation, the facts of the investigation are likely to be revealed to the government, you should tell that to the person being interviewed, because there was an instance in which a person was charged with obstruction because he didn't know that his facts, as they were presented, which weren't true, were going to be presented to the government. Weingarten is a reference to another Supreme Court case that says in the instance of a union employee that employee is entitled to have a union representative available during the interview if it is believed that that person could be subject to discipline. So it's not wide open, it's fairly limited. These are the kinds of things that I think probably ought to be discussed with your HR folks, because they'll know these rules well before starting an investigation or interview. And then finally, the requirement to cooperate. Almost every company's personnel policies documents require that an employee cooperate in an investigation. What does that mean exactly? It means they probably have to sit for an interview. Could they remain quiet during the entirety of the interview? Probably. Would that look well? Would that bode well for them in terms of their employment? Probably not. But they in almost every instance are required to at least sit for an interview. So that's something that obviously you wouldn't want to keep in your back pocket. Another good reason to review personnel policies before you start an investigation, to know exactly where you stand. Finally, a couple of quick comments about questioning, and then we'll talk a bit more about the finer points of questioning. I always like to begin with baseline behavior checks. What I'm always looking for, and I think Chris would echo this, ultimately, whether it's an internal HR investigation or something that could lead to a criminal referral, you're trying to get to the truth. And you suspect that the closer you get to the material witnesses of the subject, the likelihood of getting the truth is less and less, because self-interest will become part of the equation, and people will not want to tell you something typically that is against interest. So when I say baseline behavior, those questions that Chris talked about that established rapport at the very beginning, I observe the demeanor of the witness very closely during that period, because they will be very much at ease. There's nothing alarming in those nondescript, sort of neutral questions. And then I want to make sure I'm paying attention as the questions become a little trickier, a little closer to home, how their behavior will change. Sometimes I'll even use a question at the beginning, which I know will make them uncomfortable, that has nothing to do with the matter under investigation, just to see how they react, because I want to take that reaction, because people generally will react differently when they're not being truthful. It's what all these deception detection techniques are based on. And then I want to be able to apply that later when I get to the tough questions. If I'm talking to a subject, oh, I see now that they're using that same body movement. They're looking this way or that way. They're fidgeting this way or that way. This makes me think I may be getting to something where there's some deception. Funnel method simply means that you'll proceed from a wide net. I liken this to direct exam. If you're a litigator and you know your way around the courtroom, as opposed to cross-exam, you're asking lots of open-ended questions to make the person feel at home, to gather as much information as possible. And if this is a subject or a reluctant witness, you may be able to use some of that broadly obtained information to show inconsistencies later. So it's important to spend time bringing in a lot of information at the beginning. And I'll stop for just 1 second to mention one of I think the pitfalls of most folks that are taking on interviews is that they believe they can get it done in an hour. And they schedule them 45 minutes, 45 minutes, 45 minutes. I think in reality, if you've got a tricky subject or reluctant witness interview, you need to plan for at least a couple of hours. It may not take that long, but don't tie your hands by leaving yourself only so much time so that you force your way through to the end. I'm not going to mention much about credibility and detecting deception. There are as many ways out there and tricks and approaches to detecting deception as there are investigators, whether someone looks left or right, whether their eyes dilate, whatever it might be. I think it's just most important to have a basic sense of what people do and how they react when they appear not to be telling the truth. And there are real clear indicators. One of the things that I always notice when I'm talking to people that I think are showing deception is that sometimes they answer the question with a question. You ask, did this happen? Why did you do that? The question will be coming back to you, why would I do that? Or I swear I didn't do that. Those are the kinds of things that I think most human beings will pick up on as displaying some level of deception. And again, when you focus on that and you think you've got deception, that's where you start bringing in more direct questions and really pushing and trying to get the answer. And I'll make a final mention of protecting privilege. It's tempting, especially with a witness that has a faulty memory or a witness that you're trying to get more information from, to present information that you've developed elsewhere in the investigation, and sometimes that helps, or even information that you have before the investigation. I would just caution you to be careful about divulging something that will then essentially waive privilege. Be very thoughtful about what you show to witnesses so that you're not inadvertently waiving privilege.
We've all become a little more comfortable with remote interviews or video conferences post COVID pandemic. And certainly more and more interviews are being conducted remotely than in person. There are certainly some advantages to that. It speeds up the pace of the investigation. It can lower costs. However, there's some things that you have to consider in whether you want in-person interviews or remote interviews. You can't control the environment in which the interview is conducted when it's done remotely. Sometimes there might be individuals present during the interview that are not obvious to the interviewer, and that is a concern for protecting privilege. You have to make plans for sharing of documents, and you must be mindful of the fact that screen grabs can be made of those documents without your knowledge while doing those interviews. Greg, can you slip to the next slide? Thank you. When deciding to do interview either via telephone or video, you have to have a backup plan for technology problems. Perhaps a backup internet source, such as a hotspot or cell phone, in case there's an outage of your normal internet source. Be mindful that the person may be recording some part of the interview without your knowledge, and so you need to specifically ask the individual if they are doing that, or state if the company has a policy which prohibits non-consensual recording of the interviews. Make them aware of that. Next slides.
So we're running very late on time, and we only have a couple minutes left. I want to skip to Jeff. If you talk a little bit about, once you've conducted the interview, you've navigated all these difficult issues, can you talk a little bit about the investigative report, and then we'll try to take the last minute or so and answer whatever questions have remained here.
Sure. And the one question from Jeffrey Phillips, any thought on the effectiveness psychology of written Upjohn warning? I think that's basically the same as recording an interview. I think you're likely to scare people away with that. And again, that's why you want to have two people present. The investigative report, let me just get to the heart of it. Question is oral versus written report. I'll save all the reasoning. Written report is much better. You might have the same issue years from now. There could be a merger. Any number of things could happen, and you won't remember what was done. Normally, a written report is better. Second decision point is, what about privileged materials being in there? What about recommendations that can look like admissions? What about scope creep, things you found out during the investigation that are relevant to something, but not to the thing that you were investigating? I would say on that, consider multiple reports. There's nothing wrong with having a factual report, the one that you can give to the government if you want to, a separate report that has recommendations, a separate report that might contain privileged materials. So it doesn't have to be one report. And that's kind of the summary of that whole report writing section, Greg. So I'll turn it back to you.
Okay, so again, I said we had a large large amount of space to cover, a lot of material to cover, and we have very little time. So we're really out of time. Our presentation and some of the other issues that are connected to conducting internal investigations is available in the course materials. Thank you for joining us today. We hope the information was helpful to you. As a reminder, the program has been approved for legal education hours. To report your hours, click on the CEU icon on the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Be sure to complete our short survey. We'll use your feedback to plan future programs. This concludes our webinar. Thank you very much for attending.